Legal risk, liability to COVID-19 lawsuits, Part 2. Are liability waivers effective? That's our question today on Be in the Know Marketing. Hi, I'm your host, Jody Liller with Liller Design Works. Our guest today is attorney Mark Golson, a partner in the Davis, Miles, McGuire, Gardner firm. Mark, welcome back. Mark, will having my client sign a liability waiver protect my business in Arizona?
To a certain extent, it does. But again, and I mentioned this earlier, it is not a license to be reckless. It is not a license to be grossly negligent. Generally speaking, from a customer, really even from an employee standpoint, if someone gets sick at your establishment or at your office, they could claim that you negligently failed to protect them from the risk of exposure to COVID. There is a defense that is generally available to negligence claims or to what's called premises liability claims where you are responsible for your business invitees or your customers for what happens to them at your place of business. And it's called assumption of risk. But assumption of risk is not universal, especially in Arizona. Arizona is what's known as a comparative negligence state. That means that if the one that is suing and the one that got hurt that files the complaint, the plaintiff, is in a lot of states in what are called contributory negligence states, the one who is suing will lose automatically if they were in any way, shape, or form at fault, including assuming the risk of harm. Arizona is what's called a comparative negligence state. And that means that courts and really juries are charged with apportioning percentage of fault. And so, for example, it's possible for a plaintiff to prevail and collect a judgment on a negligence claim, even if the plaintiff is 99% at fault for the harm and the defendant is only 1% at fault. Now, with a waiver, you could argue that the plaintiff has basically said, look, I am acknowledging that this is the risk, and no matter what happens, I'm deciding to be 100% at fault. And as long as the business or the establishment exercises semi-reasonable precautions, if they are merely negligent as opposed to reckless or grossly negligent, it's probably going to be good enough to defend or at least to apportion fault away from the establishment and to the person that got sick. But at the same time, it is absolutely critical to remember that a waiver or a release form by itself is not a guarantee against liability of any kind. And again, it's not licensed to violate your own policies, to act recklessly, and in particular to blatantly ignore guidelines that are out there by, for example, the CDC. So it is helpful, but it is not necessarily dispositive.
Mark, that was so informative. Thank you so much for joining us today and sharing your expertise and educating us about the coronavirus and relation to liability.
I am one of those folks that have underlying risk factors with COVID. Take care.
Throughout the COVID crisis, Mark has continued to help businesses comply with local and state guidances regarding the reopening of businesses in the midst of the pandemic. If you want to see more episodes of Be in the Know Marketing, then join us on Facebook, Liller Design Works. And hey guys, don't forget to subscribe to us on our YouTube channel, beintheknowmarketing.com. All one word, no spaces, beintheknowmarketing.com. Stay safe, be well, be in the know. Jody Liller with Liller Design Works. We'll see you soon.